To your life.
Done, sir. Good evening, everyone. It is my pleasure to welcome you all to the Global Symposium 2025, hosted by the Global Alliance for Alternative Dispute Resolution Center, also known as the GAADRC. Of course, the GAADRC is a distinguished initiative of the Global Council for the Promotion of International Trade, serving as a vital platform for forces to promote global trade and delivering excellence worldwide, other than resolution by courts. We are a dynamic community that promotes social cohesion amongst practitioners and non-practitioners in the alternative dispute resolution ADR field, and promoting, of course, education and research. Our mission is to promote alternative dispute resolution as a key pillar of global trade and justice. Through the Global Alliance for Alternative Dispute Resolution Center, we unite organizations to advance mediation, arbitration, and conciliation, ensuring fair and sufficient dispute resolution beyond courts. By, of course, fostering collaboration, education, and reform, we aim to create a more effective and accessible system for resolving conflicts worldwide. And the Global Symposium 2025 is a flagship event of the GCPIT. We designed to foster meaningful dialogue and collaboration across industries. And this platform provides a unique opportunity for thought leaders, innovators, policymakers, and industry experts to share insights and strategies shaping the future of business, technology, and sustainable development. I am Prithvi Sai, and I'm honored to be your host for today's webinar. So today we focus on a particularly transformative theme. It's called Navigating International Trade and Investment Disputes, Sector-Specific Challenges, AI-Driven Innovations, and Access to Justice. So with the world evolving faster than ever, this session will explore how innovative technologies and human-centric strategies are redefining the geopolitical landscape. So we are thrilled to have an incredible lineup of speakers with us today. We have Ms. Akasha Rose, who is the founder of Women in Blockchain Impact, and will share insights on the impact of AI on international trade and ADR. We have Ms. Preeti Khasgir, Director at TechCorp International Strategist, will provide an outlook on digital ADR and their trends and innovations. We have Mr. Ajay Sharma, the Chief Legal Advisor at Corpotech Legal, who will delve into enhancing and promoting use of ADR in corporates. All right, so before we get started, a few housekeeping notes. Let's ensure that our microphones are on mute during the session to avoid background noise. And yeah, so the session, of course, is being recorded, and we'll share the recording and other resources, of course, afterward. All right, so without further ado, let's kick off today's panel with the first session being the impact of artificial intelligence on international trade and ADR. Our first speaker, as aforementioned, is a trailblazer in the blockchain industry and a leading voice in decentralized finance, environmental markets, and public goods, Ms. Akasha Rose. With over 6 years of impactful contributions, Ms. Akasha has been at the forefront of leveraging blockchain technology to drive real-world change. She's the founder of Women in Blockchain Impact and the original Miss Blockchain Australia, playing a key role in promoting inclusivity and strategic innovation in the blockchain ecosystem. Her expertise spans tokenomics design, regulatory compliance, governance models, as well as sustainability, ensuring that blockchain solutions align with ethical and social responsibility. Beyond blockchain, Akasha has expanded her focus to AI, currently leading an AI-driven fintech startup specializing in agentic AI solutions for financial trading. Her work explores synergies between AI and decentralized finance, developing intelligent trading strategies and optimizing market performance. With a keen interest in international arbitration, ma'am is a member of the Chartered Institute of Arbitrators, also known as the CIARP, working to address the legal and governance challenges of AI-driven and decentralized technologies. Her mission is to create fair and effective dispute resolution mechanisms that foster trust in the digital economy. We are honored to have her with us today. Please join me in welcoming Ms. Akasha Rose. Over to you, ma'am.
Can you unmute yourself, madam?
Thank you for the beautiful introduction. Are you able to see my screen now?
Yes.
Oh, beautiful. All right. So Hello, everyone. We're here today for a little bit of an experimental talk, really, on an area that is super interesting to me. So please come down the rabbit hole with me on the impact of AI on arbitration. Okay, so I won't go much into who I am because of that wonderful introduction, but if you do want to reach out after the call, or you can find me on X, Web3 Arbitrator, and also I have a website. So yeah. Let's get into it. Imagine a world where AI arbitrators resolve disputes with lightning speed, no delays, no egos, and no missed deadlines. So I've put a bit of a cheeky image up there of what we might think of as a lawyer, and then maybe what a lawyer could be in the metaverse, okay? Anything's possible. So today we're going to be exploring what is possible and what probably still is a bit more of a sci-fi kind of legal dream. Now, AI and Web3 together have the potential to democratize dispute resolution, bringing it potentially to people who might otherwise lack access. Now, many areas of law, litigation for a long time has been a war of attrition. The parties with the deepest pockets prevail. So AI and arbitration has the potential to disrupt this model by making dispute resolution faster, cheaper, and more accessible. Now, for anyone in the audience, perhaps who's unfamiliar with what arbitration is vis-a-vis litigation, basically the thing to keep in mind is that arbitration often happens on an international scale, so the parties might be from different nations, and it's private versus public, and how then the enforcement happens isn't just through the national court system, it's through the application of the New York Convention being applied through a national court system. But I don't want to go too much into that because that's not really our focus. A focus here is more AI, Web3, and expanding access to justice. So for true justice in arbitration, it has to be low cost and efficient. Traditional arbitration, would you believe, is actually expensive, often even more expensive than traditional litigation, definitely too expensive for small claims. And so this means that many disputes are still going unresolved simply because they're not worth the cost of pursuing. Now, AI can change that by making arbitration more scalable and affordable, opening the door for mass arbitration, even of smaller disputes. You might not be aware, but e-commerce giants like eBay and Amazon have been driving dispute resolution via AI for over a decade, resolving millions of consumer disputes without any human intervention. So the real question now is, can AI scale beyond simple cases to handle the more nuanced, high stakes, even investor state kind of disputes whilst maintaining fairness and enforceability? And I'm going to play this little video here if it loads.
Lots of the things we're going to do in the future will be in virtual reality worlds. My avatar could sue your avatar on this kingdom of virtual reality, and there would be a jury to decide who is right. The jury, we didn't define if it is human or not human. It could be perfectly robots, and the defendant could also be robots. Maybe one robot could sue another robot because he didn't do some job well, and maybe the judge go to trial, and other algorithms made of robots could settle the case. So robots and VR are within the limits of possibility from here to 10 or 20 years.
All right. Now, the common disputes that you'll see in international trade and arbitration often have to do with an agreement for supply, a subpar product is delivered, and there is, dispute about payment, and then there's, of course, the arbitration. So the difference that we're looking at here and what Federico is talking about is that in the economy of the future, agents are contracting with agents, AI agents, and those agents are then potentially also arbitrating disputes. And so through escrow on blockchain, enforcement can also be done automatically via smart contracts too. So a completely different world we're talking about in the future. So here's a bit of a tech stack of what AI in international trade may look like, just so you can get your heads around it. First off, there'll be things like automated trade negotiations already happening with things like Pactum AI, where they have half a decade now of autonomous negotiations. You've got smart contracts, which you might know about, things like Ethereum and Layer 2s, which enable automated compliance and agreement enforcement. AI-driven compliance and risk assessment so that trade agreements can adhere to regulations. Products like Clear Trade tackles money laundering, red flags of management, bills of lading validation, and sanctions screening and ESG. HSBC checks 1.35 billion transactions every month across the 40 million customer accounts. And then, of course, you've got automated cross-border payments. You might have heard of a blockchain called Ripple, which facilitates fast, low-cost cross-border transactions for large financial institutions. AI-powered trade dispute resolution, which we'll zoom in more in, where AI arbitrators may resolve disputes in real time. And then finally, decentralized AI governance and DAOs. So let's look at what is GLMs versus agents. Okay, GLMs you're probably familiar with, you probably use them. ChatGPT is a very common one. However, they don't understand. They really just spit out the words through prediction that are most likely to come next. So definitely not legal experts. They're fancy autocomplete. However, that said, ChatGPT took the bar exam in the US, scored the top 10%, and did so in only 6 minutes. So I don't think any human is going to be able to do that soon. So they can review millions of documents in just very short periods of time that may take humans lifetimes. So this is very useful in multi-party disputes where you've got cross claims, counterclaims, third-party claims, and maybe multiple avenues for resolution. However, we now are in the age of AI agents. So AI agents, very different from GLMs because they include 3 more essential elements. Firstly, they're autonomous. They're designed to interact with their environment, e.g. through APIs and databases. They are then able to make decisions based on that information. And thirdly, they're able to take actions to achieve specific goals without ongoing human input. So self-learning, adaptive, goal-orientated. Why do they need to be on-chain? So in legal tech, one of the downsides that's talked about is the concept of the black box, opaque and proprietary reasoning that can't be challenged, such as the sentencing technology that's in the US. But with Web3 agents, every action is recorded and auditable. Also being decentralized, anyone with a crypto wallet can access them. Crypto wallets are free to get, very easy to use. And they can also take their actions on chain to execute smart contracts for the automatic enforcement without the external need for human oversight. They can also be managed by DAOs, allowing communities to co-own and manage agents and even the agentic tribunals. So let's just consider for a moment what arbitration brings to international trade. Basically, it's a private and efficient way to resolve disputes without going to the court. It's faster, it's private and confidential, so no public records, so media circus. It's neutral for cross-border disputes, no home court advantage, and it's customizable, so parties can choose their own arbitrators and rules. Now, the ICC registered 890, that's the International Chamber of Commerce, 890 arbitration cases in 2023. And ICSID, the International Center for the Settlement of Investment Disputes, also administered 330 cases in 2023. So it's quite a large industry on the international scale. But the question I have is, if it's built with flexibility in mind, why can't it adapt to let AI arbitrators handle cases? Arbitration versus mediation, if you don't know, arbitration generally is binding and is backed by a legal framework. Mediation, on the other hand, voluntary, non-binding. So we really are in the area of what's it going to take to make AI arbitration binding. So AI and arbitration today, you've got things like the American Arbitration Association's Clause Builder, generating arbitration clauses that meet legal standards. To be valid, arbitration agreements generally need to include essential elements, and you'd be surprised how many of them don't include them, such as governing rules, seat of arbitration, arbitrator selection, so forth. So Clause Builder basically reduces the risk of invalid agreements. Also, it's being used for predictive research and document review, particularly where there's massive data sets. But we do know that AI must be being used more in arbitration because the Silicon Valley Arbitration and Mediation Center released these guidelines last year, and you can download them from the site. But as a quick overview, they really just make sense. You need to understand your AI tools. You have to make sure that arbitration is meant to be confidential, so you have to maintain confidentiality. Interestingly, you don't have to disclose that you're using AI tools, which is a bit different from some US jurisdictions, which if you make submissions with the help of AI, you need to disclose that. You need to be competent and diligent in their use. You need to maintain the integrity of the proceedings. And this is interesting, non-delegation decision-making. Basically, the arbitration agreement, how it's conceived at the moment, you've been hired as the arbitrator. You're not allowed to delegate your decision-making powers to the AI. That's basically a breach. And the last one is respect for due process. So the question I have is, do arbitrators need to be human? Now, there's already platforms out there like Kleros.io, which have adjudicated over 2,000 Web3 cases, not with AI yet, but they've just released their AI agentic court, or tribunal rather. So we can look at basically the conventions that inform arbitration on the international scale. So there's the UNCITRAL Model Law on International Commercial Arbitration from 2006. Article 11 says, no person shall be precluded by reason of his nationality from acting as an arbitrator. So they do say person and nationality, but they also say his, and there are women arbitrators. So, there's room for that. So New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards was 1958, of course, before any AI was even conceived. Article 2 there defines an arbitration agreement, but doesn't specify that the arbitrators must be human. Article 5 includes that an arbitral award may be refused enforcement if the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. Now, this is really super interesting because what I take from this is that if the parties agree to an AI arbitrator, enforcement could still potentially be valid under the New York Convention, with some caveats, which I'll talk about later. So, and this is given the legal principle of party autonomy, which is under UNCITRAL Model Law, Article 19, which is subject to the provisions of this law. The parties are free to agree on the procedure to be followed by the arbitral tribunal. So that's on the international scale, but we're still dealing with national jurisdictions as well. And across these jurisdictions, the requirements for arbitrators can vary significantly, and national laws may impose specific criteria that will obviously preclude AI arbitrators. For example, we have good repute requirements. The Arbitrator Code of Professional Responsibility from fmcs.gov emphasizes the essential personal qualifications, including honesty, integrity, impartiality, and general competence. And AI could be regarded as having those, but those criteria are generally regarded as human traits. Then you have mutual nationality requirements. For example, in India, Arbitration and Conciliation Act 96, Section 11 provides discretion to the appointing authority regarding the nationality of arbitrators. But for example, the ground under Article 5 of the New York Convention, a court can refuse enforcement of an arbitral award where there's been either an invalid arbitration agreement under governing law of the agreement of the actual agreement. So, theoretically, if it's interpreted that you can't have AI arbitrators in a certain seat of arbitration and yet you have them nonetheless, that agreement may be void under that country's laws. If there's due process violations, if there's an excess of authority of the tribunal in making the award, or if there's been improper tribunal composition, i.e. the tribunal was not constituted in accordance with the agreement or the law of the seat of the arbitration. And so also the award isn't binding in the country where it was issued. So any of those really could be fatal, I think, to the enforcement. But this all becomes a bit irrelevant if we consider what if enforcement is already happening automatically on chain, okay? So, this is where we start to consider the possibilities of agentic courts that automate enforcement because the parties have already locked their assets in escrow via smart contracts. So the issue of enforcement, becomes irrelevant. So here is Kleros.io doing basically this exact thing. Its objective is to resolve disputes quickly, efficiently, and transparently. It's done so with 2,000 disputes already. And the main thing that they focus on is disputes that need to be resolved almost instantly. Like you need it done today. So things like esports, which you might not generally consider, but you can't go to court or even arbitration that will take, weeks or years. Esports, it needs to be decided right now. Esports is really big in Web3. So as such, we can see that ADR in Web3 is part of an ecosystem that's evolving into a dynamic economy where AI agents, human participants, and market forces can interact in new and novel and creative ways. So AI agentic core elements, what will they be? I think we'll need to establish the frameworks. It'll need to be on smart contract and blockchain. There's going to have to be human oversight and appeal mechanisms, and there's going to have to be data and security measures. Would you trust an AI to arbitrate? There's always going to be risks, but in these instances, what we're seeing on ClearOS is that it's faster than humans, it's immune at least to emotional bias with caveats, and it's always available 24/7. They say crypto never sleeps, but nor does AI. So I'm not going to go deep into the risks of AI in international arbitration here. It has been covered in other talks, but I think it's really important to flag them and be aware of them for future consideration. And I think the main one, particularly for arbitration, is that confidentiality privacy risk. Is AI learning from your confidential data, for example? And the other one is, yes, AI can be biased. Anyone who's gone to ChatGPT or Midjourney and tried to create an image of a woman that's not 17, skinny, white and blonde knows that, or a business person who's not, a 30-year-old white man in a suit, knows that it's been trained with data that has created inherent bias. So garbage in, garbage out. I see a lot of challenges and opportunities here, basically more opportunities, really, and interesting challenges. I think it will be a journey of adoption, just like Web3 has taken time to be adopted. We're going to, businesses over time will have to build trust in these kind of AI rulings. But I think that as we see more real world assets moving on chain, and there's very, very big movements towards that now, those trust concerns will already diminish because the assets are on chain anyway. And that also then pertains to enforceability of the AI arbitration awards. Some talks I've seen on arbitration and AI, they say, oh, well, can't be enforced, so there's no point talking about it. Well, if it's all on chain, theoretically it can be already, because you don't need to go to a court to enforce it. I think we're going to see more standardization of AI in arbitration, so the insertion of AI-specific clauses in agreements and blockchain-based dispute resolution driven by DAOs. And of course, we're going to have to do more to overcome this AI bias and confidentiality challenges. But I do think that maybe a decade from now, we'll be seeing institutions like SEAC and ICC developing AI-specific procedural rules and even maybe dedicated divisions within their arbitration institutions. I've had a bit of a go at creating an AI model clause example. I won't go into it here, but you can maybe just pause this screen and have a little look at it. I think this is something that's, if you're going to want to have an AI arbitrator, it's going to definitely have to be in your agreement to be valid. That's the main element of the New York Convention, is that party autonomy. You have to agree to it. So, and also I think it's very important to include an aspect for human review, but under what those considerations that human review might take place. So, for example, I've put here, it's limited to specific grounds such as errors of legal interpretation, bias detected in the model, or failure to consider key evidence due to limitations. So in conclusion, what's possible? I'm definitely seeing potentials for a global decentralized arbitration network where there's AI-driven dispute resolution for Web3 and the metaverse. I see instant arbitration for definitely microtransactions and DAOs. And potentially, as we bring more access to dispute resolution to more people, I think that this could be a real revolution for the legal industry. So yeah, everybody, thank you so much for listening. I hope you've learned something from it. I had a great time going in deep to research all of this. And if you'd like to reach out to me, please just find me on X or reach out to me via my website.
Thank you, ma'am, for such valuable insights on the impact of AI in global trade, as well as the importance and of necessity value for arbitration in the future. Just one of two questions. The first is, in what ways do you believe that AI can enhance the efficiency and accessibility of ADR mechanisms for like international trade disputes? And could you share any examples of how technology is already streamlining these processes?
Yes. So those are really good two questions. I would say really take a deep dive into the agentic space. There's already tens of thousands of AI agents on chain. A very large platform now launching them is virtuals.io. Now many people have probably played around maybe with creating a ChatGPT agent. But that's not on chain. So these other agents are on chain, and where this becomes very important is, and this is only just happening in the last couple months, so I'm very, very happy that and excited that I work in this area. But how this is important is that these agents are literally the world's next billionaires. It's very, very, just like an AI can take the law exam, the bar exam in 6 minutes and score 90%. These agents can very quickly identify ways to make money. And you might have heard of Truth Terminal, made millions of dollars. Big VCs got involved and threw their money at it to say, hey, here's some money, do what you can. So we have agents like Luna from Virtuals, was the first agent on chain to make an agent-to-agent transaction. So it's almost like these AI agents now are creating their own alternate economy where they have millions of dollars in their control, and they're paying other agents to promote them or to create content for them, and they're all doing this autonomously. So we need to then think about, well, how will that apply to international trade in the future? Because and the sort of things that are happening, the sale of goods, or even whether they're physical or non-physical across borders, potentially there's going to be agents in the sense that you could literally have a car that is on chain as its own agent that is managing its own, like a self-driving car that's managing its own economy. You could have forests and things like that. So I think there's mostly potential for the economy as we know it to completely change and ultimately to be potentially even managed by major AIs. I think the corporations of the future are even going to be managed by these AIs and these AI agents who are optimized for making money on large scales. So that's how I see international trade shifting. It won't happen this year or next year, but I think 10 years from now, I'd be very surprised if big corporations aren't almost being run by AI or AI agents. And then in terms of accessibility, I just think that platforms like Clearos and other ones that will pop up around that, there's a few others. I'm sorry, I can't remember their names right now, but if you do a bit of searching on Twitter, you'll find them. They're popping up because they care. This is what the thing is. People in Web3 care about the decentralization of power. They care about the decentralization of decision making. So ultimately, what they actually do care about is fairness and justice and equality. And so you do see these platforms popping up where you can, register your organization to have these kind of automatic dispute resolutions happening. So I think it's just going to democratize access to justice, because you won't necessarily have to pay for a lawyer or to pay for adjudication. You can simply, perhaps, if the agreement allows for it, and I think more agreements will, put the agreement on a particular Web3 platform for adjudication, and maybe have a decision, later that day based on the AI and the data and comes at a very low cost to you. So I just think it's just going to cause the mass adoption really of justice almost for people in the future that, you know, previously couldn't access it due to the thresholds of entry of affording a lawyer and everything.
Perfect, ma'am. That's exactly what we were looking for. And just to follow up on that particular question, what regulatory or industry-led initiatives do you believe are essential for guiding the responsible use of AI and ADR, right? And how might these frameworks evolve to keep pace with the rapid technological advancements?
Yes, so most countries, particularly those countries that are part of the New York Convention, they do have their national legislation with regard to, you know, things like arbitration that I was talking about before. So I think there's probably going to have to be some workshopping of, you know, do AI arbitrators come within the frameworks of these definitions of their national jurisdiction legislation, and if they don't, do they need to? And then if they need to, what changes have to happen to the legislation for them to be included? So I think it's going to be a slow process of a build-up of awareness, and I think ultimately it's going to be driven by the market, not by the legal industry or regulators. It's going to be just like we saw, you know, in the US, you know, blockchain and crypto take off. Then the SEC came down and said, no, Ripple, you know, you're a security. And then, you know, new people are in power and the SEC got blown away. And now, oh, Ripple around the world, you know, blockchain, BTC, Ripple is going to be part of our state treasury. You know, it's going to be market driven, I think. So right now, we're not going to see regulators and legislators come in and examine their, you know, the definitions of what is an arbitrator. But I think 10 years from now, if there is global adoption of these kind of standards simply driven by its, you know, cost efficiency and its speed and its ability to scale, then, you know, the law will have to catch up with that.
Thank you, ma'am. Thank you once again. Thank you very much for your amazing insights and for answering all of our questions so wonderfully.
Thank you. It's been wonderful. Thank you.
Now let's dive into our next session, which is Digital ADR, the Trends and Innovations by, of course, Ms. Preeti Kastagir. It's my pleasure to announce a distinguished expert in the fields of cyber law, global intellectual property, and international dispute resolution, Ms. Preeti Kastagir. A registered patent attorney in India, Ms. Preeti brings over 18 years of experience in navigating the complexities of intellectual property, cybercrime, and international commerce mediation. Ma'am is a renowned global speaker, frequently addressing strategic intersections of technology, cyber law, and business in the Industry 4.0 era. As an active participant in the ITU regulatory workshops, she contributes to initiatives on sustainable development goals and cybersecurity incident response teams. Beyond her legal and advisory expertise, Ms. Preeti is a seasoned software and hardware patent strategist, specializing in IP portfolio research, smart contracts, cross-border tech transactions, and patent litigation strategies. Her work ensures businesses achieve win-win solutions in product clearance, licensing agreements, and patent risk management. She's also an internet entrepreneur and the founder of TechCorp International Strategist, a global IT consultancy headquartered in AeroCity, New Delhi. Her insights have been featured in BBC World, Nature Review's Drug Discovery, Business World, and Biospectrum Asia. And of course, having represented India's delegation at the Cyber Drill event in Malaysia, she has played a pivotal role in fostering global partnerships between academia, ICT organizations, and government agencies, driving innovation and digital empowerment. We are honored to have her with us today as we delve right in where her expertise will offer valuable perspectives on the future of dispute resolution, cyber governance, as well as global trade. So please join me in welcoming Ms. Preeti Kastagir. And over to you, ma'am.
Thank you so much for a wonderful introduction. And first of all, thank you, Santosh and Akasha, for delivering such a insightful session on the overall landscape of how AI and digital stuff is changing the whole landscape of how arbitration can happen and how dispute resolution can happen. Today, I'll be taking deep dive in the landscape of digital ADR, the type of ADRs, and what are the trends in terms of what we can expect from 2025 coming from the understanding of where alternate dispute resolution started at the first instance. So first of all, we need to understand why there's a need of digital alternate dispute resolution in 2025 and beyond, and particularly from the point of view where the businesses is global in nature, whether it's from the B2B or it is B2C kind of business. Now, understanding how AI is going to change the mediation or how blockchain integration with the smart contracts is changing the understanding of how the dispute resolution can actually happen is the question we need to answer. If we go back to the traditional AR methods where face-to-face interaction was the need of the hour, where the lawyers used to travel from one country to the other just to have that interaction, and it used to take a lot of time in terms of the deployment. As Akasha pointed out very well, that it's not the legal landscape which is going to drive the innovation. It is going to be the market analysis of how any kind of dispute which is happening has to be resolved in a time frame manner. And that is one of the reasons why mediation in India is being deployed, and it is being part of almost all the agreements, all the contracts which are happening right now. Let's even before discussing into what the tools available to us right now, let's understand the concept of why we need dispute resolution in the fast, speedy manner. Now, the why question is very important, but for the why to happen, Akasha also pointed out that in the agreements and in the contracts itself, that reasoning has to be there, how the dispute is going to be resolved. So even for any kind of online dispute resolution to be deployed in a given scheme of business or in a given scheme of dispute, the proactive approach would be to include those in the contracts and agreements. And particularly when we talk about everyday, like right now, we have the LLM models, which are the large language models. Few months back or after the lockdown, it was all about ChatGPT. So now it is ChatGPT versus DeepSeek. And probably in a couple of days, we will have more LLMs in place. So the question to be answered is how this gig economy, which is developing right now, can be married to the online tools which are available to us in terms of dispute resolution. So there's a growing trend in terms of the ADR procedures as far as the cross-border disputes are concerned. And I would be discussing about a case which is still ongoing in India in terms of the dispute which is happening and how the ADR is being utilized. But at the same point of time, if it was dealt at the first stage, the results would have been achieved in a fast, speedy manner. So what are the challenges when we talk about understanding the collaborations which can happen and the deployment of even the AI agents for that matter? What is important right now is we don't need to wait for the dispute to happen. What is important is, like in most of the cases where digital ADR process is already in place. So we have eBay, we have different courts, whether it's Singapore, Hong Kong, Dubai has come up in big way because it is fostering the blockchain economy for the companies to harness the new age of doing business. So the technological advancement is one aspect. The another aspect is the stakeholder collaboration. So the stakeholders need to take that proactive approach of building those relationships and integrating those relationships onto the blockchain. So there is something called as RAG, which is on which you can actually build these kind of products, and each AI agent can perform certain function. So AI agent can even perform the function of due diligence. So what kind of due diligence a company has to incorporate, that is again a proactive approach which needs to be seen. what is the challenge in achieving this international harmonization is the international treaties and agreements. So there has to be a lot of discussion around the legal frameworks, because once we have that framework that is acceptable to one or more countries and the parties who are involved in the dispute, and what is the acceptance of the digital processes in terms of understanding the digital area process, whether it's mediation, whether you're going for arbitration, or we go for negotiation. So one step back, if we go back and understand the gig economy per se, in the dispute resolution clause itself, it ways. First could be the negotiation, second is the mediation, and third is the arbitration. In the three-step process, we can online dispute where negotiation itself, you can have online mechanism to resolve the dispute. If we talk about the reality, what is happening is in terms of the enforcement mechanism. So right now it is basically in a hybrid situation, which is believed to be a better situation as compared to giving everything to the AI agents to work with. As Akasa also talked about, the arbitrator being a non-human, but human intervention at the same point of time would be required. There's a term called as HACCP. HACCP is basically a well-known term in the food technology industry. So HACCP stands for Hazard Analysis Critical Control Points. In a similar manner, wherever there is any kind of business pitch, there has to be a HACCP mechanism to resolve the dispute. So there are two things. What happens is, if there's a dispute, how are you calculating the damages? Are the damages in terms calculated of liquidated damages, or it is unliquidated damages? So if you look into the Singapore laws, liquidated damages basically is defined in the agreement what will the formula of calculating the damages. But if it is unliquidated damages, then there are different scenarios how the damage would be calculated, because at the end of the day, when we are using any kind of dispute resolution mechanism, we are trying to get to a situation where it is a win-win for the parties involved. And we have to consider this online dispute resolution as the fourth pillar. So there are, say, for example, two parties in dispute. So party one is pillar one, party two is pillar two, party three may be the negotiator, arbitrator, or the mediator, and party four is the technology. So the reality is, how are we going to bridge the hybrid mechanism of combining traditional legal framework with the new technologies so that we are able to foresee what is incoming and build those pillars in the contracts which are drafted at the first instance itself, so that if at any given point of time in the near future, such kind of situation arises where there's a dispute, this hybrid enforcement can come into play. So what are the benefits of hybrid enforcement? That is basically, if we look into the factorial stuff of executing stuff in the offline world, and the rest could be the online world. Right now, we have for any kind of business which is online in terms of a buyer-seller kind of arrangement, most of these websites, they have their own online dispute resolution. And very good example could be eBay. So eBay utilizes an automated system to resolve their disputes between buyers and sellers. Then we have Hong Kong International Arbitration Center. We have something in Singapore also. Now, the main point is, if we look how the landscape of the capital economy is working right now, is a lot of startups are budding, not only in India, but globally. And there are situations where the startups are exploring the opportunities in different countries. So what about the resolution about in those cases? Because this kind of model where there's buying or selling, there is some kind of online dispute resolution. But in terms of startup where the venture capitalist money is involved, it is very important to understand how to resolve those issues. And that is one case study I'm going to discuss today. And there are jurisdictions right now, even in India, we are still contemplating in terms of what kind of blockchain law we can get India onto, or what chain onto which this kind of arrangement can happen. So where there is the clarity is not there, it is always good to utilize the traditional way of resolving the issue and combining it with a hybrid situation where uh, a part of the resolution is in the offline world and the other part is in the online world, which is the benefit of the hybrid enforcement. 2020 and beyond, we all know the global shift happened in the digital ADR space, making it the new norm for dispute resolution. So if we understand the advantages, definitely it eliminates the physical meeting and the travel cost and the overall expense involved for the party. The accessibility is more, the efficiency is more, and it is a speedy trial for the parties involved. Now, what is very important is we always look into the factor, okay, these are the technologies which are available right now. But what about the pre-dispute planning phase? If we look into any of the cases which are landmark, the missing link always has been the pre-dispute planning phase. So what is important here is the drafting of agreement and timely review, maybe for example, every 6 months. Even the kind of tool we are using for the online ADR, that tool can be agreed upon every 6 months. So if any dispute arises, so we are not disputing how we are going to resolve. So the pre-dispute planning phase is going to take care of it. Then definitely there is enforcement planning. We need to have an enforcement strategy in place, targeting the target jurisdiction and how things are happening. Types of digital ADR, we have mediation, negotiation, and arbitration. And the efficiency of process would always be enhanced by the communication and the documentation. The fact which is very important for the companies to realize right now, especially for the startups, because most of the startups are going to the IPO phase in a timeline less than 3 to 4 years now. So, and if we understand that, we need to understand that the process of digital ADR has to be there in the pre-dispute planning phase itself, so that if any kind of dispute arises between the parties, it can be resolved in an efficient manner. Now the foundation. Now what is the foundation of the digital ADR? It has to begin with a properly drafted dispute resolution agreement. It has to identify the need of digital ADR. So it's basically the clauses have to include that this is going to be resolved digitally. How it is going to be resolved digitally and what will be the jurisdiction involved, that again has to be specified in the agreement. What digital platform you're going to use should again be whether it's proprietary in nature, because there would be a lot of venture capitalist firms who would be developing these kind of platforms, because their investment is not in one company. At one point of time, they are invested around 50 to 70 different startups globally. So specifying the digital platform is very important. And in the previous slide, we talked about like this should be a regular affair in terms of every 6 months, so that you go back and see what's new and develop over it. If I talk about the current situation right now, for last 2 weeks, there is a lot of development on the LAMP chain. And on the LAMP chain itself, you are able to utilize different AI agents to resolve certain issues. And that again can have some kind of effect to resolve the issue in a fast, speedy manner. Now, what are the platform rules? Again, if you are using a particular platform for resolving an issue, what are the rules and how it's going to work? That understanding and that human capacity building exercise has to be done for the parties who are involved on a regular basis. You don't need to wait for the dispute to arise. You have to be proactive in acknowledging that if this happens, we are going to take care of this scenario. So it's basically kind of a dispute drill which needs to happen on a regular basis, so that the dispute itself doesn't arise. And at the same point of time, the platform is in a RAG phase where it is learning from the humans. So it's basically a human intervention would be there. And with the human intervention, even the platform becomes smarter. Again, acknowledging what kind of digital technologies would be used for the proceedings. So those kind of understanding and details have to be there in the disclosure of the agreements, and especially from the point of view of the startups who are raising funds, whether initially or at any of the phases before the IPO. So if any kind of dispute arises, they know how to resolve it. So this is basically a drafting template for that. If you want, you can just take a screenshot for the same. It's a very open-ended clause. However, what I generally prefer when I'm drafting contracts is including a definition section and being close-ended. Because if a word is open-ended, then that can be interpreted under different acts globally. So it's a good strategy to include a definition section and define the words clearly, and that word is under which act of which country can be defined, because most of the businesses right now are cross border. So one law doesn't play in the whole scenario. It is the different acts and how the different scenarios or events are happening. Based on that, that act will happen. So the agreement should specify, acknowledge the use of digital technologies. So if the agreement itself is stating that we'll be using digital technology to resolve the dispute, then it becomes easy if there is any kind of dispute, because party at the first stage itself agreed to the proceedings, how it would be conducted in the online world. So in the previous slide, we talked about the pre-planning. Now let's talk about how the enforcement can happen, looking into the different parameters of jurisdiction documentation, which can be brought onto the blockchain also. So let's dive a little bit more into the understanding of the smart contracts. Smart contracts per se is basically steps which has a determination step, and here you need a techno-legal but plus coders to code a smart contract, because lawyers can definitely talk about where the pain point is and the coder can code it. So here what is important is what is the local technical requirement in terms of country specific, because another important thing is SDG goal, that is sustainable development goal. So there again, a very important factor which is being talked about is to reduce the energy which is required to run these kind of systems. So carbon footprint also has to be taken into care, and those kind of hardware specifications and software compatibility issues are part of the enforcement planning in terms of where the server would be, whether it's a cloud server, what are the arrangement in terms of who are the people who be working at the coding side, who are the people who are be working on the execution side. And authentication standard is again the encryption protocols and the access controls. When we talk about the encryption protocols, is it GDPR compliant? How it is happening? Again, the contention would be the parties involved. What are the scenarios where the product or the service is being delivered? Is it through C or is it through just the online media? That will decide the compliance issue. Again, another important thing is if a country like China is involved, how the translation of the agreement will happen in the real time. So those issues also have to be taken into consideration, and bodies like UN, who have particular bodies who are looking into the different stuff of the implementation part, would play a critical role to lay the framework which can be utilized by different companies for execution. Now, the jurisdiction documentation package would be different for a country like China. It would be different for a country like US. It would be different for a country like European Union. So the local laws have to be deployed on the blockchain, and the smart contract has to work in accordance with that, so that the cross-border enforcement happens. And the relationship with the local enforcement experts who understand the technicality and the legal expertise to enforce it would be one of the pivotal issues which would be looked in the year 2025. Okay, so now we already talked about the pre-dispute planning phase, which is basically the drafting of the agreement. So as I talked about, I'm going to talk about a case study which is ongoing. It is Byju's insolvency and ADR process. So Byju's is an edtech company based out in India. It has been in the limelight for quite a while because a lot of money has been siphoned off. And these are the timelines. I'm not getting into the case study as such, but the understanding here is if they would have deployed online dispute resolution at the first instance itself, they could have looked into where that money is missing. So they own a lot of money to BCCI, which is again enterprise in India, which is looking into there was a sponsorship deal, and this company Byju's owned them some money. Now, what is important here is to look into that the loan company, which was based out in US, this is Glass Trust, they moved to Supreme Court because they were removed from the committee of creditors. However, Supreme Court did utilize online portals to resolve the issue, but what is important here is the current issue where $533 million is missing. Now, if this kind of arrangement was there on a blockchain to resolve it, this money could have been traced. Now, the problem statement is the money is missing, and it's still a lot of discussion happening where the money is going. There's a role of a controversial businessman right now. So the point is, if it would have been on blockchain, every transaction could have been verified. And when venture capitalists are investing so much of money, they should be utilizing platforms where even to have a transaction, because blockchain is all to do with peer-to-peer networking. So you cannot do a transaction until unless the people in the block, which is, it can be a private blockchain. So in the private blockchain, if until unless everybody doesn't agree, the transaction won't happen. To avoid such kind of situations, what I believe is a lot of startups are going to build products around it so that this kind of situation can be averted at the first place. Now, what does online ADR brings in? It brings in transparency. The audit trails can be seen if we are deploying the blockchain. The stakeholder communication is much better. What are the risks? Because inadequate data protection measures are not there, and the risk of unauthorized access. However, when blockchain can also be public and private. So if you have that private blockchain, this mishandling of so much money could have been taken care of at the first place. Now, what can be done in this year and the coming years where we can deploy the AI agents? We can have this blockchain on the smart contract and utilize different LLMs also for the trading purpose, because it has to be techno-legal and it has to be done on a certain data set of developing such kind of a platform. Firstly, there has to be human capacity building exercise for the people who are involved, and that needs communication from all the stakeholders. So that can be facilitated. And then there has to be a pre-phase documentation, which we already talked about. Different agreements can be made and executed on a smart contract so that everybody is on the same page, holding video conferencing every 6 months just to understand where these enterprises are. And particularly, as I said, as far the buyer and sellers are involved, that is taken care by their internal online processes in terms of resolving the issue. Where these things would be taken care of would be in the startup world, where there can be dispute because of the money involved. And we already saw the Byju's case where there is siphoning of the money. Loan amount has been taken, but still where the money has, the trail of money is still a question which needs to be answered. Then, of course, when we have the blockchain, it provides you real-time updates. You can see the continuous updates of the financial transaction, and particularly where the stakeholders are involved and venture capitalists are involved, they would like to see where the money is being where the money is going to resolve or to solve what kind of problem, whether it is to pay for the employees, whether it is to pay for the setup. So those things can be taken care of when we have it on a blockchain. And it improves the overall management also in terms of having it on a blockchain and utilizing the, one is the blockchain, and another thing is the new age tech, which is being developed in last 6 to 9 months. So it would be interesting to see how things are in next 1 year, because other LLM models are also coming in news apart from DeepSeek. So that is one interesting, I would say, way the business is being run, and where legal people are going to play a very pivotal role. Implementing the emerging technologies, we already have artificial intelligence negotiation platforms. However, how these platforms can work, deploying different AI agents to automate certain tasks. Say, for example, if there is some kind of human capacity building exercise which needs to be done with certain employees, it can be personalized. And that personalization is going to upskill the employees in certain manner. And that is where, artificial intelligent negotiation platform is going to personalize the experience. Another point of view is whether only AI can handle negotiations. From the point of view of human intervention and the applicable laws across the globe, till date, it is being regarded that human intervention or human intelligence is the core. It has to be part of the system to have a fair understanding. But yes, when the bias is concerned, and if we take out the EQ, which is the emotional quotient, there we can definitely have some use case studies where study can be done utilizing just the AI agents to resolve a dispute in question. Second, we have the smart contracts and the blockchain-based resolution system. So you can automate the dispute resolution mechanism to smart contracts. And in smart contracts, it can be like if there is a business and there is a scope of work. In scope of work, when work delivery model is executed, then X is executed in the smart contracts. So it is more transparent in nature. Then we have the language and natural language processing applications. So in that, real time, say for example, we can use the LLM models to provide real time translation services during the international proceedings, and at the same point of time have the expert on board to just check what is happening in real time. So number of people deployed for the same service will be reduced, but at the same point of time, natural language processing applications is going to be utilized more this year and in years to come. So how this assessment is happening at the first place? What are the capabilities and the challenges? Identifying the capability and challenges, we can deploy AI agents that can be developed in a fast, speedy manner. And defining an outcome can be one scenario where we can see whether this AI agent is able to work or not. and accordingly, make the amendments and changes in the way the AI agent is determining the events and the scenarios. What will be the roadmap? It is to prioritize the timelines. Say, for example, if any work which was executed by 50 people, that work with the AI agents can be executed maybe 5 to 10 people. So that is the power of AI in the deployment of ADR in the online world. Implementation has to be strategic and it has to be monitored progressively. As I said, you have to identify the critical points in the process and work on it so that that critical point is taken care of. Now, how to optimize these digital initiatives? So it has to have a clarity in terms of, we talked about the hybrid model. So hybrid model is all to do with looking into the traditional aspect of resolving an issue, and at the same point of time, looking into the technical aspects of the digital process. Collect data on key performance metrics, KPIs to track progress. Here, again, we can deploy the AI agents to expedite the process of collecting the facts. The more important factor, apart from the deployment of ADR, would be the human capacity building, because even to train a AI agent, humans have to upscale themselves in terms of understanding the kind of tech which can be deployed to resolve the issue at hand. So 2025 and beyond, we are going to see a lot of experimentation and collaboration between the countries. Lawyers have to work with the coders to develop those strong blockchain platforms. Some platforms are already there. Again, when it is country specific, parties to the dispute would like to utilize those kind of platforms because then they understand the laws and the regulations around it. What is the future of the digital ADR globally? What is important here is the drafting. If we go back to the phase number 1, do it before the dispute arises, so that when the dispute arises, if any, you're able to resolve it in the best possible manner with the best possible tools, and having that technical clarity is very, very important. Thank you so much. If you have any questions, happy to answer.
Well, thank you so much, ma'am, for that amazing lecture. Just one question, ma'am. Thank you for just sharing just one valuable insights, but especially regarding the cross-border landscape and how we could enhance the digital ADR decision-making process was very insightful. But ma'am, what are the primary challenges did you believe that organizations face when transitioning from traditional ADR methods to digital solutions on a global scale? And can these hurdles be effectively addressed?
Okay, so particularly there are challenges in terms of how the parties who are involved, they look into the contracts, and in the contract, if the declaration is not proper, then at the first space, the party who is at fault would not like to go for an online ADR. They will try to dispute and refute that. So what is important is to have that clarity in the contract at the first place. So here the lawyers have to play a very pivotal role. So it's not the marketing agency of the company, but it's going to be the lawyers who are the part of the enterprise, how they draft the agreement so that if there's a dispute, they're able to resolve it. And in any dispute, the first thing is, whether you write a 100-page agreement or a 5-page agreement, the judge or the mediator, arbitrator is going to look into the section of dispute resolution. So what is important are only 2 basic clauses. One is the dispute resolution clause, and second would be the damages. If those 2 clauses are written proactively in the best possible manner, thinking what future can bring in, I think that is going to solve the issues. And most of the folks actually, because in the initial stages, what happened is most of the startups, they think that it is a burden to, hire a good lawyer or a law firm to execute that. But if they do it at the first place, they would be saving a lot in the future, because nothing else matter what is written in the exhibit. As legal professionals, we know that two clauses is going to solve everything.
Perfect. Thank you. Thank you very, very much. And with that, we come to our next and our last session, which is enhancing and promoting use of ADR in corporates by Mr. Ajay Sharma. And our next speaker, as I've mentioned, Mr. Ajay Sharma, he brings a unique blend of legal, corporate, and entrepreneurial expertise, making him a distinguished figure in the fields of cyber law, corporate law, and international HR management. With a career spanning over 25 years in leadership roles across semiconductors, IT, fintech, and manufacturing. He has worked with global giants like Ericsson, Xilinx, and Cadence, optimizing operations and enhancing organizational efficiency. So before transitioning into law, he was an entrepreneur in HR tech, health tech, and fintech, equipping him with deep insights into the evolving business landscape. His legal expertise covers a broad spectrum, including IT laws, data protection, intellectual property, and commercial dispute resolution, giving him a well-rounded perspective on the intersection of technology, business, and law. Mr. Ajay's experience in transnational HR management across Europe, the US, and the APAC gives him a global outlook on corporate governance, compliance, and regulatory frameworks. His passion, of course, lies in helping startups implement based HR and legal practices to drive sustainable growth. And to conclude, I mean, with his vast experience in both corporate strategy and law, Mr. Ajay is here to share his insights on the evolving role of technology in dispute resolutions, international trade, and corporate governance. So please join me in welcoming Mr. Ajay Sharma. And over to you, sir.
Hi, sorry, I'm actually in the, some other place, so I'm just trying to connect my laptop. Meanwhile, a very good presentation by Ms. Preeti. I'm part of the ODR, Preeti ji, so I know that, what you mentioned is, much beyond what normally people think about, the online ODR is. So thank you for that. While I, put my slides on, the concept of arbitration or the ADR, alternate dispute resolution, is quite good, but still in the corporate sector, it is not necessarily that every time they want to go for it. Why they do not want to go for it? Because many of them are not even aware of that, what can be done, in this space. Are you able to see my screen?
Yes, sir. Yes, yeah.
Just a second. Let me just put it in. Yeah, is it visible? Slideshow is okay.
Yes.
Okay. So, I'll be discussing about, how do we enhance the enhance and promote the use of the ADR in the corporates. If we look at, the scenario in India, people thought that, the regular way of managing these things is using the standard legal processes, which means, go to the court, get your, things settled. The court is marred with so many cases, at this moment. It is very difficult for the court to manage. If I go to the very, very lower level thing, like section 138 or the loan cases, where by default there is a clause available that you should go for the arbitration, but people don't go for it. Why they are not going? Because they feel that it is not going to be beneficial to them. Whereas the concept of ADR or the alternate dispute resolution was basically that, it should help the corporate sector as well as the general, public to get the justice outside the legal system, which is available to, the general public otherwise. the essential part, why the corporates, when I talk to the corporates, I have worked with the corporates, and we've always used to have an arbitration clause, but nobody was interested in, going for the arbitration or mediation, or for that matter, negotiation also. Why it was not? Because people don't believe that, this is a good legal system, or this is a good alternate system which is going to help them get the justice. Whereas it is a very cost-effective one. The confidentiality is, kept in the manner, which we believe that, it is going to be. The business relationship are going to grow because, it is between two parties, where the discussion is happening, not between, with the, normal court, which we normally think about. And as we know, the Arbitration Conciliation Act of India, it actually says that, these decisions of the ADR are binding on the parties. So people still feel that, going to the court is a better way rather than going for the ADR. And in this particular session, we are going to discuss that, how it is going to be managed, or how it should be managed, so that we can enhance the scope of, or the usage of the ADR in the corporate sector. In fact, during the COVID, and even before that, Justice D.Y. Chanchur, he actually emphasized that, more and more cases should go to the ADR. If we look at the, the Arbitration and the Conciliation Act, which we have, it says that I'm taking the arbitration as a case because, I cannot take all three types of, the alternate dispute resolution in this particular, conference, but I'm taking arbitration as one of the, important one. Section 7 defines very clearly that the arbitration agreement has to be there, but it has to be, in writing. When Ms. Preeti was, explaining that, how the smart contracts are getting done, how the entire thing is, getting managed. So just a second. So she was defining that, how the smart contracts are going to be and how it should be written. If you look at the clauses in the commercial contracts, or even for that matter, employment contract also, it is a very simple way, they have mentioned that, the this particular case can be handled at the arbitration. But there is no clear-cut clause, or there is no clear-cut arbitration agreement which has been done. So one of the things is that, do people actually realize that what is the importance of the arbitration? That's where the first thing starts. So which means that educating the people, both the corporate as well as the people, those who are there, those who are with whom the corporate agreements are done, are they aware of that, what is the importance of the arbitration? Section 8 also says that, court must refer dispute to arbitration if the valid agreement exists, which means that if there is a clause available or written in the, agreement, it should be taken care of at the arbitration court or arbitration level, or with the arbitrator. Section 9 allows the interim relief from the court before the arbitration starts, So it means that, the court also suggests that, if there is a process of the arbitration which is mentioned in the contract, they should be referred, there in the arbitration system. Arbitration tribunal can also grant, the interim relief. These are some of the very, very significant provisions which are available in the ANC Act, Arbitration and Conciliation Act. And, if people say that, maybe there is going to be, some kind of negotiation, mediation, and I may not get justice, or even if there is an order from the arbitration or arbitrator, it will not be enforceable. No, that is not the case. Section 35 actually says that the awards are binding in nature, like any civil code. And Section 36 says that it is enforceable, as a court decree, except, some limited grounds, where the Section 34 is applicable, where they say that, yes, the arbitrator's order can be challenged in the court, but those are very, very limited. It is basically when somebody says that, no, I don't think that the arbitrator was, impartial, or there was a bias in that, or there was a connivance of the, one of the parties with the arbitrator, and that's why the order has been passed. Or there was some procedural errors, that how it should have been done. that, when the first hearing was there, then the second hearing was there, how this entire method has, taken to the next level. So understanding of the use of the arbitration method, or for that matter, mediation or reconciliation method, is very important in, to be promoted in the corporate sector. And when I say corporate, doesn't mean that the big corporate, big corporate are very good, they understand all these things. But corporate includes, even the startups also. It includes, some of the mid-sized companies also. But they are not really aware of that, how it can be done. I'll share a live example. I was scrutinizing the employment contract of few companies, and I found that even the HR head was not aware of that, how to use this arbitration clause. They thought it is a standard clause, which anyway has to be written. So they are just, writing it. So it means that the education is not even there at the head of the or CXO level also, that, how this can be a beautiful way of managing the disputes which are arising out of the contractual obligations. The key takeaway, which I wanted to, bring in, that the Act ensure that arbitration is a speedy, binding, and enforceable dispute resolution mechanism. Now, this system exists. How do we take it to the next level? A lot of, good things, were discussed earlier in these, in this session, that what should be there in the arbitration clause or the arbitration contract. One is the scope of arbitration should be defined clearly. What is that, which they are looking for? Is it a commercial kind of thing? In commercial, what is the scope, what is the nature of employment? How they are going to use this particular, method in case there is a dispute arising? Which are the governing laws, or the seat of arbitration? I'm using, since we are talking in the context of the India, I'm saying that it has to be very clearly mentioned that where is going to be the seat of arbitration. A lot of issues sometimes come that, that the company is based in Bangalore, or, the person is in Delhi, where this is going to be. It should be clearly mentioned in, whenever you're defining the arbitration clauses or, arbitration agreement. Which are the institution arbitration setup, which is going to be there? We have one central, follow model, which is being used. There are bigger ones, which are available. But now a lot of ODRs are also there, online dispute dispute resolution models or the platforms are available. Even those can also be mentioned, in the agreement. How many number of, or arbitrators are going to be there? Normally, when you write these arbitration clause, people say that, the company which is, say, if I am the employer, or if I am the company which is giving, the contract to the vendor, I will decide, about this thing. But the law says that you can actually have both of them can decide, about the arbitrator. In case if they are not aligning on one single arbitrator, the law allows that you can have a 3-member panel, which means one person coming from the side of the, the other party, and both the disputed parties, can have their representative, and there can be one senior person above them who can be the main arbitrator, So it's a 3-member tribunal, which can be defined, but it has to be mentioned that how it is going to be managed. How the interim reliefs are going to be there under section 17, or obviously, as I mentioned earlier, the section 35 and 36 ensure that, it is binding and enforceable law as per the ANC Act. Yes, where the problem comes, when the clauses are not, drafted properly. When the agreements are not clearly defining that, what is the scope of this entire thing. So what the education will not only go up to the level that how these arbitration or the ADR system is going to help in dispute resolution, it also goes to the level that how it will be managed also, which means that how the arbitration clauses or the arbitration agreement are to be drafted. But how do we, promote these? Now, it is very, if you look at the law, it says that, yes, you promote it. If you talk to the Supreme Court, they said that, yes, people should go for the ADR rather than, coming to the court. But how do you do that? So what we need to do is that ensure that all commercial employment and the vendor contracts have a well-drafted arbitration clauses. This will happen only when people are aware of these things. Train the legal, commercial, and the HR teams. Whosoever is a stakeholder in the system, to ensure legal is normally aware of, but the commercial and HR department may not be totally aware of that. How this is going to be managed. HR is a big, big department, because thousands of employees work for the companies. How they should know. They should know that how it is going to get managed. Am I audible?
Yes, sir.
Hello.
You are.
Yeah. Okay. Sorry, there was a call in between. So
Sure.
encourage that there is an internal system also which exists in this organization. It is not only dispute between the parties which is outside the system. It is within the system also. How this mediation, negotiation, or reconciliation method has to be used, which means the culture needs to be developed that we are here to solve the issue, we are here to resolve the issue, rather than getting into the system wherein we go to the court and start fighting with each other. Industry associations, we have CIA, FICCI, SHM, they should document some case studies that, okay, these kind of cases were there, and this is how the ADR has helped dispute resolution, and how the company has got benefit out of it. It is not only the the money part, it is the effort, it is the reputation, everything is at stake if they go to the standard court of law. They can be CEOs and the general counsel, etc., should endorse that I want an alternate dispute resolution method to be used in my company. I'm not interested in getting into the legal issues. We have so many the legal the arbitration institutions. I see that they are doing some kind of training on a regular basis, but I think they are still not to the level that the normal corporate CXOs and the management level people understand that is the benefit of this. It needs more. Government is anyway advocating that we need to have the focus on this, and they should encourage more and more people to go for this. And now the ODR has come. Beautiful. I am associated with one of the platforms in India, and you will be surprised that I get so many cases through the this ODR platform, but unfortunately I have to make some of the decisions ex parte because people don't understand the importance of coming to these platform. The other party, for example, is, let's take a case of a loan. When the person who has taken the loan has defaulted, and the case has come for the ODR or for the ADR method. But people feel that if they come here, they will be cheated, or they feel that they will not get the justice. Now that education will improve, but ODR is a very good mechanism, very low cost way of managing the disputes, which otherwise it goes to the court. So ADR is a very efficient, cost effective dispute resolution. It requires education, promotion. Industry associations have a lot to do in this particular aspect. As part of the standard management training, when you have standard management training institutes, we need to provide this as a focus, that go for the alternate dispute resolution instead of using the standard court for this dispute resolution purpose. That's all I had for this session. I'm open to question. In case if there are questions, I'll be happy to answer them.
Thank you so much, Mr. Ajay, for sharing valuable insights with us on, on enhancing and promoting use of ADR in corporates, as well as the challenges and misconceptions that are associated with them. So just, I have two questions. My first would be, how is technology, transforming these ADR practices within the corporate sector? And you did mention that, people are still aren't aware of ADR as a substitution for traditional negotiation practices. So, how is technology transforming these ADR practices? And, where do you think these emerging innovations, do you see them as, very pivotal in the future?
Yeah, it is actually, so it is not necessary that all the, all the cases are, in the right manner when we talk about the technology part of it, The ODR, there are many platforms. I think there are 6, 7 platforms which have come. And this was, actually initiated by the Niti Aayog initially, supported by Justice Chanchud, that we should use the technology to get into the dispute resolution. The number of cases coming to the ODR system is currently not in all areas, but especially in the default cases, loan default cases. And fintech is, very high area, to get in. You will be surprised that in last year, when I saw that how many cases are there of the default for the small loans, it is around 9.5%. Now, if suppose all these cases go to the court, the judges will be totally drowned by that. So this ODR is helping a lot. What we need to do is that ODR is still, it's like a CRM package. But I think if you introduce the AI in the system, that suppose if I have the complete list of documents available and the AI recognizes that, okay, these are the default, these are the issues, these are the facts, and let me give, some summary to the arbitrator. So, okay, I'm a law graduate, I understand the arbitration, but arbitrator need not be a lawyer. So there can be large number of arbitrators which can be added into the system. So technology will certainly help because it is online, it is easy, so it will certainly help. So as you said, the current ODR systems are good, but they can involve the AI to make it more effective.
Thank you, Singh, for that answer, especially with ODR and using it in corporates. Just the second and final question. So, what role do you believe that should corporate governance and regulatory frameworks, can they play? What role can they play in incentivizing the use of ADR? So, and what practical measures can organizations also implement, right, to foster an ADR-friendly culture, because people are still not educated of it as of yet. So, what can corporate governance do as well as corporates as well as the regulatory frameworks? How can they go hand in hand?
So, the corporate governance, the large institutions are there doing job well. So I understand, they are doing their job well. The problem is that people, those who are at the CXO level, they are not aware of it. So if we do more programs, and that too at a very low cost, and that too using the technology, now we have online, coaching, online, sessions which are going on. If we take this as a mission, that in next 1 year, we will educate at least, 1,000 companies or 2,000 companies, specifically those who are having large number of such kind of cases. And that CXO training is very important because that is where the thing starts. If the CXO is aware of that, they will certainly ensure that the contracts have the arbitration clause or there is a specific arbitration agreement, which has been signed. So, apart from the government institution, it is the industry associations which can actually push it a lot. So, industry association, management institutes, and the general training, to the CXOs will make it easily, understood by the corporate people.
Got it. Perfect, sir. Thank you. Thank you very much for your answers, for your amazing insights and your patience in answering the questions. And
thank you.
With that, thank you, sir. Thank you very much. With that, we come to an end. So what an insightful and thought-provoking session this has been. We've delved into a diverse array of ideas, from the evolving role of AI in international trade to the innovations shaping digital dispute resolution and the growing importance of ADR in corporate settings. So a huge thank you to our incredible speakers for sharing their expertise and their insights. We're very grateful for your time and the wealth of knowledge you've shared today. Last but not least, also thank you to our wonderful audience for joining us and contributing with questions and enthusiasm. We hope you leave with actionable strategies and fresh perspectives to shape the future of the workplace. And of course, be sure to connect with us and our speakers on the social media platforms and websites, to continue the conversation. And let's not forget to mark our calendars for the next event, where we'll dive even deeper into the transformative forces that are shaping the future of work. And yes, until next time, this is Prithvi Sai signing off. Stay inspired and keep driving change.